Okay, we're going to be talking about something a little more practical for your purposes than some of the history that we've covered so far. We're going to talk about child custody right now. And I'm going to split this up into at least two videos because they're probably three, if not more. The first thing I want you to understand is who can file for custody, and then give you some terms, because a lot of the terms that we use in child custody, if we use them in lay parlance, they often get misunderstood or used to mean other things. And then I want to talk about how we determine who gets custody. Then we need to talk about how to modify or change custody. You can't just always change who has the custody of a child. And so those three things I'd like to split up. Who has rights and some terms, how to establish custody, and then how to change custody, because there's a different standard. All right. So first, when we talk about custody, the law is going to favor parents. We're talking about biological parents of children. Now, this can change over time now that we have the right to marry someone of the same gender who is the parent of that child. A parent, for purposes of child custody, means one that is biological and that's been established. It's easy to establish the mother's claim of biology because she was there when the child was born. And then the father's paternity can be established in a variety of ways, which we've talked about previously. And when we've talked about paternity, we've talked about a legal justification for establishing paternity based on the biology. So previously we've been talking about biological children. Adoptive children. So if you adopt a child, you become the equivalent of a biological parent for legal purposes. And that's for all legal purposes. That's for custody, that's for support, that's for wills, trusts, and estates. It's not just child custody, but it's all of this. And so when we see same-sex marriages now, we frequently see adoptions take place because that is how both parents get status as the parent. Now, there are some states that are allowing a birth certificate to suffice, but it may not be enough in some places, and so adoption can be an option. Birth certificates can be, depending on what the state law says. If the state law says two women in a marriage are presumed the legal parents, whether neither are biological, or if one is biological and the other is not, either there will be some legal determination, either because of a statute that allows the birth certificate to suffice or because of an adoption. So we have this. Then we have the concept of termination. The only exception to parents having rights to have custody to their children is the doctrine of termination. When your parental rights are terminated, you no longer have any rights nor responsibilities over your child. Termination is a process with some finality to it. So judges are reluctant to do it. And so in termination of rights cases, it's typically abuse, but it can be a step parenting situation. Termination cases are different from state to state. There are some states where you can choose to sign your rights over. So let's say we have a situation where biological father is found after a period of time. Biological father in some states, used to be more, this is largely going away, can sign over the rights to mom. If mom says, look, you haven't been a part of this kid's life, I don't want you as their father, and I don't need child support from you. Because remember, the child custody rights stop, but their responsibility for support also stops in a termination case. That can be a voluntary termination of rights. It can also be voluntary if mom gets remarried, biological dad hasn't been in the kid's life, step parent wants to adopt. Some states allow that as well. Other states, such as Indiana, very rarely allow termination. And the termination cases in Indiana involve involuntary termination most of the time. So we might terminate a parent's rights in cases of severe and long-standing abuse. And I mean, CPS has been involved. They haven't done anything CPS or DCS, whatever they call it in your state, has wanted them to. And they've been either a long-standing drug problem or have abused the child personally. In those cases, rights might be terminated. One interesting thing that you need to know is that in termination cases, we use the standard of clear and convincing evidence. So it's not beyond a reasonable doubt, but it's not the civil standard either. It's not 51%. It's not preponderance of the evidence. It's clear and convincing. Because the theory is that losing your children is worse than losing your money, but it's not as bad as losing your own life or your own freedom. And so we use the clear and convincing evidence standard. It's also a procedure where in many states there's a statutory requirement for counsel to be provided. So you have a constitutional right to counsel whenever you are going to have your liberty taken away or have that possibility. And typically that's not in civil cases, right? It's criminal. But this is one case where you could lose the rights to your child. We're going to hold the state to a higher evidentiary standard, and we're also going to appoint you counsel in many states where there's a statute that requires that. Okay. This termination is an exception to biological parents having rights. If your rights have been terminated, you do not have the right to custody, you can't fight for custody, you also do not have to pay support. We favor, and your book talked about a 2000 Supreme Court case, we favor biological parents. This sounds great. Biological parents should have rights. There are some examples, though, when a biological father is either identified later in life or for some reason doesn't know about the child's existence and then doesn't have a relationship with them, and maybe the mother either fraudulently said he gave consent to adopt, or fraudulently said I don't know who the father is, and so the child gets adopted by a loving family who wants the child, and then 3 or 4 years later biological father realizes he has a child, and the courts in most cases are going to favor the biological parent, and that can be very difficult, and these are situations where there's no good answer, and everybody loses something at some point. Okay, some other people who may seek custody of a child are grandparents. Their rights are not going to be as strong as parents will, but there are statutes in some states that allow for grandparents under the right circumstances, and those circumstances are usually that they've been caring for the child, or one or more parents are unavailable. Let's say we have a situation where dad is deceased and mom is in prison. Grandparents might be a place appropriate to have custody. So I'm writing at a very awkward angle, so my handwriting is getting worse and worse. Then we have the category of people who are not biologically related to this child, or maybe they're more distant, maybe they're an aunt, maybe they're an uncle, maybe they're not related at all, but they stand in loco parentis. That's in the place of the parents. And so let's say we've got the situation where dad's deceased, mom is in custody, and friend has been watching the child for some period of time. This person over time might be under a statute what we call a de facto custodian. They've had the child, maybe because of an emergency, maybe because of the wishes of the parents. They've had this child for a period of time, and now they are a de facto custodian. They have to prove such under statutory factors to a court in order to be able to ask a court to establish custody, but it is possible. So we have parents, unless their rights have been terminated, and I mean biological or adoptive. I do not mean step-parents. Step-parents do not have custodial rights over children. Step-parents fall in, if they do at all, to this in loco parentis de facto custodian status. They are not parents under the code. Adoptive parents are, step-parents are not. So unless they've been terminated, we talked about termination, then in some limited circumstances, grandparents have the right to seek custody, as do people who stand in loco parentis. This is where I'm going to take a break, not because it's the appropriate time, but because, of course, the battery in my camera is dying. So we'll come back for part 1.5. Okay, so now we're going to talk about terms in the second half of this video. And so these terms may vary from state to state, so take a look at what your statutes say. But for the most part, these terms are fairly applicable. When we talk about custody, there are multiple different kinds of custody. The two big categories are legal and physical. Legal custody is who can make decisions for the child. Physical custody is who physically has the child overnight. So this can be split up in a variety of ways. Let's say the mother has, and so let's talk about physical custody: primary, full, and split or shared are all descriptors that we use to discuss physical custody. So let's say mom has primary physical custody, which means she gets the child more often. And that's Monday through Friday. And then dad has physical custody on the weekends. And so let's say it's every weekend. That's an unlikely situation, but it's possible. So she has primary physical custody. He has a lesser amount of custody, but he does have some physical custody. So what happens if the child is with dad on a weekend and he needs to go to the hospital? Well, unless dad has shared legal custody, he cannot make any medical decisions for that child, because legal custody is who makes decisions for that child. So even in a situation where you have split custody with one parent having a lot more time with the child than the other, it's can be beneficial for both to have shared legal custody. That means they can both make decisions for the child. And when the child is in their custody, they can do things like check them into the hospital, give consent for surgery, those sorts of things. It is possible to arrange this in just about any way that you would like. It's certainly possible for one parent to have full legal custody. It's unlikely for the parent that has full legal custody to have no physical custody, because that just doesn't make any sense. But aside from that, we can have both parties with legal custody. We can have one party with legal custody, and that's generally speaking the person that has more physical custody. Primary custody is the person that has more time with the child than less. Full custody means full custody, means that the person who has it has complete custody of the child. And then we have situations where if we have shared custody, there are plenty of situations where each parent has the child a certain number of days. And so it might be 50-50. And in a 50-50 situation, we might have a 2-3-2 split. So we have mom has the first 2 days, dad has the middle 3 days, mom has the next 2 days, then dad has 3 days, and it just kind of goes back and forth like that. Or 2-3-2, mom, dad, mom. The next week is 2-3-2, dad, mom, dad. There's a bunch of different ways that that can happen. But that's split or shared custody. My kid popping in to get a snack, I guess. I don't know. Okay, so that's physical custody and that's legal custody. Then we have something called visitation. Visitation is not custody. Visitation means you have, it generally means that there are no overnights involved, or there aren't overnights on a scheduled basis, like every Wednesday and Saturday. If dad has overnights Wednesday and Saturday, then he has partial custody. If he sees the kid on every Saturday afternoon, that's just visitation. He doesn't have any custody. And in that sort of situation, it might be feasible for mom to have legal custody because he only has the child a short period of time. Visitation is shy of custody, and that also means it does not trigger support reduction. When we get to the unit on support, we'll talk about the fact that the person who has the child more often is the person who is most likely to receive support. But Not always. The person who has the child most often makes a significantly higher income. Then we'll talk about that later. But support is reduced for the person who's paying it by however many days of custody they have in a typical week or month. And that only means custody, which is overnight. Visitation is a shorter period of time, generally not overnights, and it does not trigger custody reduction. In addition, visitation can be supervised or unsupervised. Unsupervised is what it sounds like. Supervised visitation is generally for cases of abuse. And so we have a judge who wants to allow an addict or someone who has been abusive. Maybe they lost their temper really badly and physically abused their child on one occasion, and a court says, I'm not ready to terminate your rights, but I don't think you should be alone with a child, so you need to be supervised. Supervised visitation is generally reserved for situations where a parent is not as fit as they should be, and it runs the gamut. Visitation can be supervised by the other parent. Not a great idea, because you don't want to have a fight in front of your kids. It can be supervised by a step parent. There's generally either a person designated. So let's say mom is the parent that has some troubles and she needs supervised visitation, but her mom, the maternal grandmother of the child, is generally speaking a good person to have in the kid's life. This family member can supervise visitation, and in order to pick who does that, the court's gonna take testimony. Parties can agree on it if that's something that's part of their plan. But it can be someone that's a family member that's designated by the court. If not, it can be someone that the court appoints, and in those situations, it has to be paid for, and that's tough. So you've got someone who's in a bad situation, who shouldn't really be around their kids full time and not be around their kids alone. They are likely not going to have a whole lot of money. And is it possible that money can keep them from seeing their child if they have to pay the supervisor? Yeah, generally speaking, this person hasn't made good parenting choices anyway, but money can be an issue when it comes to supervised visitation that's court ordered, and that's by someone court appointed. Okay. So those are, generally speaking, the terms, except for the legal standard. And this legal standard is generally speaking the same everywhere. It was in a discussion board that I posted this week. The standard for child custody, who wins, let's say if there's a fight, is based on the best interest of the child. Now, does this mean every custody arrangement is made with this in mind? No, because many custody arrangements are either informal, meaning there's no written agreement with the court, or the parties just agreed on it. And let's say, for instance, we've got a situation where mom wants to go get a PhD in another state, so she's going to be there for 3 or 4 years. And so during those 3 or 4 years, they agree that she's only going to have summertime visitation or summertime custody, and dad's going to have the kid the rest of the time. Is that what's best for the child? And let's assume they agree on it. Probably not. What's best for most children is to have relationships with both of their parents, barring abuse or complete ineptitude. But this is a situation where mom has rights and desires as well, and if she goes to get a PhD, the parties can agree that their custody is what benefits the entire family, and they just agree on it. People agree on custody all the time. That is not optimal. That is not statutory. That doesn't comport with what they would get from a court. Totally fine. If you can agree, agree. These are situations where when we go to court, unless there's a situation of abuse and you absolutely have to get a kid away from a parent, then it's almost always better to agree, because what is in the best interest of the child is, as your textbook suggests, as everyone knows, completely subjective. Can it be based on inappropriate things? Absolutely. What is in the best interest of the child? This is the legal standard that the court is going to use when the court determines who to give custody to. And it's based on statutory factors. These only come into play when it's a custody fight, when you have to go to court and ask a judge to establish custody. Before we get there, as I said a minute ago, many parents will have an agreement, especially if they're a married couple that is divorcing amicably and they just don't want to be married anymore, but they love each other as parents and they want what's best for their children. That case doesn't need to go to court, okay? In addition, let's talk a little bit about procedure, and this will help you later on in the course. So those people who agree, they may never go to court at all, and they may choose or they may not choose to use the standard of the best interest of the child. We'd like to think that most parents would, especially if they can agree with each other. And so they may not go to court at all. They may just have this informal custody arrangement, and if it works for them, it works for them. Fantastic. More power to you. Problem with that is that when someone loses their mind, because we lose our minds over our children, there is no recourse because there's no order, so there's no order to violate. There's also no order to enforce. You can't go to the police and say, well, we have this informal custody arrangement and he decided he didn't want to give me the kid. Oh, you don't have it on paper. Sorry. So logistically speaking, these cases, there's a tier of cases that has no court intervention at all. There's no order. There's nothing that the court can enforce. Then there are cases where we do agree, only we're going to write this down and file it with the court. These cases are pretty good too, because if you can agree, it's always better. But then we can go to the court, and if something happens, we have a plan. We have an order to enforce. And if one of the parents loses their minds and decides not to follow it, you can go to court. You can show it to a police officer, and you can say, I need this order. There's a court order for me to have my child, or judge, the other party has violated our agreement. Do something about it. That's tier number 2. We can get to tier number 2 a couple of different ways. Number 1, the parties can do it themselves. Most, if not all, states have pro bono forms online. In Indiana, it's done by the Supreme Court. You can go on the website. You can find both kinds of cases. You can find we agree and want to file it, and we don't agree, we need to fight, forms to just fill out pro se. It's pretty straightforward. But the parties can agree themselves and take the agreement to court. Then, if someone files for custody, a lot of people file for custody not understanding, what happens during court. Somebody files for custody, and they may be, and in fact in many states they must be, ordered into mediation before it becomes a fight. So they come to court without an agreement. They don't have one. Court is going to make them sit down with a mediator. And so if you know anything about alternative dispute resolution, mediation is the one where you have one individual. Sometimes they're a lawyer. Sometimes they're someone who knows a lot about custody, like maybe, I don't know, a juvenile court worker. And you've got, could be a retired judge, depends, the characteristics or the qualifications are different in different states. So the mediator goes back and forth between the parties to try to negotiate this agreement. And so let's say, I remember doing one when I was doing family law in law school. We had our mediation at an elementary school, and me and Mom were in the choir room on some risers, and Dad and his attorney were in like a classroom, and the mediator just kept coming back and forth. And it's nice because it separates the parties, so I don't get mad at you because I'm seeing your face and I don't like you. And it also has the added benefit of the mediator saying, here's what you want. I don't think you're going to get that from a court, because I know what those statutory factors are. I know what a court's going to use to decide custody, and you're not going to win this one. So maybe give it up. And the attorneys can do that as well. But the mediator might say, you want this, he wants that, how about you meet in the middle? and then they help you work out this agreement. So if that happens, this second tier where agreement's filed, the mediator helps the parties get to this agreement. The agreement becomes filed in the court and has the strength of a court order. Same outcome, right? Then the third type, third logistic thing that might happen is that the court decides who gets custody. And that's when we'll get into the next part of the video, which is the court looks at the best interest of the child and then looks at those statutory factors, and those statutory factors are what vary from state to state. So that's all of the terms: custody, legal, physical, visitation, the different ways that a custody can be established logistically, the fact that we have to do mediation, and then we also talked about termination in this video. In the second part, we're going to talk about how a court, if we don't agree, if we get all the way to this stage and we cannot agree, and a court must decide who gets custody, that's what we're going to look at in the next part of this video.